Well, it's another day and more twists and turns in litigation against Illinois' gun ban. Good morning, I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk, and this segment we're going to talk about the latest filings in the Seventh Circuit Court of Appeals on the case that was consolidated where a Southern District judge issued an injunction, and then 6 days later, the state asked and received a stay on that injunction from the Seventh Circuit Court of Appeals. Well, that injunction is now stayed. The law banning the sale of more than 170 certain firearms, shotguns, pistols, rifles that are semi-automatic, firearms attachments considered part of assault weapons, and those include any magazines over 15 rounds for handguns and over 10 rounds for rifles. That's been in place since January 10th. You've got a whole slew of lawsuits that were filed in state court and federal court. But in federal court in the Seventh Circuit, you have the latest filings responding to that stay that was issued by a single judge of the Seventh Circuit Court of Appeals. And some of those filings we'll go over. And then next segment, we'll talk about some gun laws that are being proposed at the Illinois State House. So stay tuned for that. But first, let's get into this. The Seventh Circuit Court of Appeals, they have of course, the docket that you can check out if you subscribe to PACER, which is the federal lawsuit tracking system. And this is the Seventh Circuit Court of Appeals docket for the case that's named Caleb, and that includes all four of the plaintiffs from the Southern District. That includes the Caleb case from the National Shooting Sports Foundation case, the Langley case, the Federal Firearms Licensee of Illinois case. So there's four different cases there that are consolidated in the Southern District. Judge Stephen McGlynn last month issued an injunction. The state asked for that stay, then went to the Seventh Circuit Court of Appeals and asked for a stay, got that stay from a single judge from the Seventh Circuit, and that judge gave the plaintiffs in this case till yesterday to respond. And the responses, and we'll get to those now here on WMAY. This one from the plaintiffs, Caleb Barnett, and the Barnett case goes over some of the arguments. They say that the state identifies no viable basis to disrupt the Second Amendment rights. Let me go back to the overview here. Here we are. Back up. There you are. All right. The state identifies no viable basis to disturb the district court's conclusion that plaintiffs are likely to succeed on the merits. It talks about the Bruin decision and how that abrogates this court's decision in Friedman and Wilson. And that's important because the Seventh Circuit Court of Appeals judge, he essentially said that whenever people respond, they have to respond to previous decisions that he was involved in, Judge Easterbrook was involved in, concerning firearms that are years old. And that's one of the things that people critical of this have pointed out, saying that the new precedent from the Bruin decision last summer from the U.S. Supreme Court changes things. But they also go to talk about how firearms and magazines in the Protect Illinois Communities Act are arms, and that firearms and magazines that are banned are in common use, and there's no historical tradition in this country of banning ubiquitous arms. Ubiquitous meaning things that are all over the place, right? I mean, you got 2.4 million Illinois firearm owner identification card holders in Illinois. A lot of them may have semi-automatic weapons that fit this category of so-called assault weapons. So continuing on with the overview here of their case, in the filing in the Seventh Circuit, they essentially say that the court should expedite the appeal. Moving on, another filing from the Federal Firearms Licensees of Illinois, they actually filed an 11-page response where the Barnett team filed a 29-page response. So some of the table of contents here from the Federal Firearms Licensees of Illinois, they say that the state's gambit of seeking a stay from this court without first giving the district court a reasonable opportunity to consider that request violates Rule 8, they claim. They also say that the irreparable harms to plaintiffs and appellees favor reinstatement of the district court's preliminary injunction. So that's the response, essentially an overview from the Federal Firearms Licensees of Illinois, and just skimming over to see what their conclusion is. They essentially say, for all those reasons laid out in their 11-page response, which appellees join in full the Barnett response, this court should deny the state's motion to stay the injunction pending appeal. You also have the case that was brought forward by Jeremy Langley. We talked with Langley's attorney, Thomas Magg, earlier this week about the Fifth Amendment arguments concerning the Illinois State Police and their statement saying that anybody that bought weapons during that 6-day injunction window, those weapons are not legal and cannot be registered if the law is upheld. Another issue entirely different. We'll actually hear a lot more about that. Some Republicans are going to be taking to the State House to condemn that statement today, and we'll see what kind of response we can get from Governor J.B. Pritzker, who holds a separate news conference on a different issue. We'll see if he can respond to what Republicans are critical about the Illinois State Police, saying that weapons purchased during that injunction are illegal under the assault weapons ban. But back to the Langley case, it's a 8-page response. And it just talks about, where we're at in this case. The arguments we'll read here shortly. It says, as an initial matter, defendants should have proceeded with their request to stay the preliminary injunction in the district court before presenting to the Seventh Circuit Court of Appeals. Instead, they jumped straight to this court, the Seventh Circuit Court of Appeals, without giving the district court a chance to consider the issue. And that's after Judge McGlynn in the Southern District was asked to stay his injunction. McGlynn said, okay, well, we got a week for you to file why you think the injunction should be stayed and for a response and so on. The state bypassed that and went to the Seventh Circuit Court of Appeals. But the Langley response in the Seventh Circuit to the stay says, as the merits, Second Amendment protects arms that are commonly possessed by law-abiding citizens for lawful purposes, especially but not limited to self-defense in the home. It goes on to talk about under the Supreme Court's precedent, this is all that is needed for a citizen to have the right under the Second Amendment to keep such weapons. There cannot be the slightest question, therefore, that the challenged laws are unconstitutional. Goes on from there. So that's the latest in the filings of the Seventh Circuit Court of Appeals in the Southern District's consolidated cases. We still have Thursday is when all plaintiffs down in the Southern District and the Northern District challenging gun bans have to file concerning gun bans that are in place, not just the state ban, but also the local bans, like in Naperville. But Naperville's case is actually up in the U.S. Supreme Court, where you have filings there. So there's a lot of moving pieces here, and we'll do what we can to make sense of it all. But as of right now, the ban on certain types of weapons is in effect with a stay on an injunction. So a lot of moving pieces. Sometimes feel like I'm getting my law degree here. You may be feeling that as well, but stay tuned. We've got much more coming up here on WMA1.